Good day, wherever you are. I greet you digitally. I'm Professor Charlie Rose, and this is Practice Ready Evidence. What we're going to do in this block of instruction is to build on an earlier block of instruction about the evidentiary rules controlling the admissibility of expert witness testimony. We're going to now look at some important federal rules of civil procedure and how they impact the deposing of expert witnesses, because there's been some recent changes, relatively recent changes, to the federal rules of civil procedure. When you reach my age, recent is truly a relative word. But there have been some changes to the federal rules of civil procedure that we need to think about as advocates when we're making the decision about whether or not to depose witnesses. So as we're analyzing a case and looking at the decision point of, am I going to depose my opponent's expert witness, we have to consider, in conjunction with the rules of evidence, the rules of civil procedure 26 and 37 as they apply to the admissibility and the cross-examination, the attack, if you will, on an expert witness. Because in some circumstances, we may actually be better off not deposing or deposing in a limited fashion and saving certain issues for trial. And that's a fundamental shift. Before the change to Federal Rule of Civil Procedure 26 and 37, as it pertains to expert witnesses, you really needed to go whole hog on the deposition of an expert in excruciating detail to make certain that you had tied them down, much like you would any other fact witness. And at least arguably now, under the rules of civil procedure, if your judge, of course, applies them correctly, there may be a different path to success. I'm not suggesting that this is the only path to success, but I do want you to be aware of it so that you're making intelligent decisions in your case analysis as you look at the possibility of deposing an expert. I really think you need to consider from the beginning, what is the purpose of the deposition of the expert witness? If the purpose of the deposition of the expert witness is to determine whether or not the expert is truly qualified, or whether or not there is some actual basis for the opinion that they want to offer. In other words, if I'm deposing to, let's say, try to perfect a summary judgment motion, or to perfect pure lines of impeachment on their qualifications, then potentially I might wish to depose. If, on the other hand, I'm just deposing for the sake of deposing, I am opening the door to allowing that expert to repair any mistakes that they made in their expert report. That's really what I'm doing. And that's what Federal Rule of Civil Procedure 26 and 37 are designed to do. They capture in stone the report of the expert and make them live with that at trial, not allowing them to depart from that interpretation unless we've opened the door through inquiry during a deposition. So that's something we really need to think about as we make those decisions. And then regardless of whether you're looking at an information gathering discovery approach to the deposition of the expert or a destruction cross-examination slash and burn approach to the deposition of the expert, in either case, I have to plan thoroughly. So how do I plan? How do I put myself in a position to be most likely effective when dealing with expert witnesses? Well, I would suggest to you that rather than looking solely at 702, 703, and 704 of the Federal Rules of Evidence and the basis of their opinions and the qualifications of the expert, we turn instead in the civil arena to Federal Rule of Civil Procedure 26A2B, which deals with the opinion, the data, the exhibits, the qualifications and publications, the compensation, and any prior testimony of the expert. All of this has to be included in the expert report. And the expert is tied to each of these things, which means that they cannot shift their opinion prior to trial unless there is an intervening incident that calls into question the opinion or that allows them to explain their opinion or to bring additional information forward. It's all a part of how discovery is supposed to work to solidify the issues before we get to trial. So the great value of Federal Rule of Civil Procedure 26 A to B is that it locks it in place. But that comes at a cost. If you want it to remain locked, if you don't want that expert's opinion to potentially shift before trial, you've got to forego the type of deposition that you might otherwise do. You don't drill into, was there anything else? Was there any other reason? Was there any other opinion? Because you're literally asking the expert to produce additional information, to perfect the weaknesses in their opinion before trial. So you need to think about that. By the same token, they're tied to their data, they're tied to their exhibits. If the exhibit that they try to use at trial was not part of the exhibits that were provided in the expert report, it's going to be excluded. So this is a way of thinking about the decision point of deposing the expert that those of us who've been around for a while have not always thought about. And those of us who practice in jurisdictions where you don't have this kind of limitation that you have through the Federal Rules of Civil Procedure, well, go forth and conquer. But if you're in the civil arena, in federal court doing federal litigation, you must consider the connection between 26 and the next rule that I want you to look at, which is Federal Rule of Civil Procedure 37. Now, 37C1 tells me that if a party fails to disclose an expert opinion or an exhibit, that opinion and that exhibit is automatically excluded at trial unless a substantial justification to accept that rule exists. And folks, I'm here to tell you that the most common substantial justification exception that is cited by the court is because the issue was opened up during the deposition process. Because a lawyer doing what lawyers do in depositions, attacking the validity of the expert's opinion, really going after them and drilling in and challenging the expert, actually created the substantial justification exception for a new or modified expert opinion at trial. So you've got to ask yourself going into the process, what do I think the likelihood is that this case is going to trial? And if I really believe that there's a high likelihood, I may forego or limit greatly the deposition of that expert so that I can hold that attack back for where it might do the most good and where I have the greatest opportunity for success. Now, if on the other hand, I'm deposing the expert to try to drive a settlement negotiation or to maybe even establish a summary judgment motion, well, then I may want to go afterwards, after that expert in a much stronger fashion. So what am I suggesting to you? I'm suggesting to you that there's a level of both strategic and tactical analysis when determining the extent to which we're going to depose an expert that did not exist before these amendments to Federal Rule of Civil Procedure 26 and Federal Rule of Civil Procedure 37. Because what's really happening is that when we get into depose, these experts are going to volunteer an additional opinion during the deposition process. And that's going to fix the fact that it was admitted under 26A, and it's going to waive the automatic exclusion under 37C1. So the practice point here is you must carefully review the expert report. And it may be that your review of the expert report, and I would even go so far as to also have my expert review the expert report, I may find the thing that I'm going to save till trial. Now that requires me to be able to forecast whether or not I think it's going to trial and to forego the potential advantage of the deposition of that expert prior to trial. But these are all decision points that should now be added to your matrix of decision points when you're making decisions about whether or not to depose. Now, I've got two ways that I want to suggest to you that when you look at the deposition of the expert, that you can go. And the first one that I want to suggest is what I call the discovery approach to deposing the expert witness. And in a nutshell, what this is telling us is we're trying to get information. We want to understand, we want to increase our knowledge of what the expert's going to say. We're going to educate ourselves. We may even be educating our client or our expert on what we look is going to happen. Now, when I'm in discovery mode, I'm trying to identify potential other parties. I am looking broadly to narrowly to create as much information as possible. I'm trying to prove the elements of my case or disprove the elements of the case. Maybe I'm looking at some cause of action that's not out there yet or a potential defense. And I'm trying to sort out what is or is not there. So I'm broad. I am questioning. I am pushing deeply for information. And it goes from the broad to the specific. And it's the classic deposition technique that we use with lay witnesses all the time. I'm previewing adverse information so I know what to do with it. I'm evaluating the credibility of the witness, and I'm evaluating the appearance, the likability factor. How do I think this witness is going to play in front of the jury? I'm doing all these things when I'm conducting a discovery-based deposition process. I'm reevaluating the strengths and weaknesses of my case based upon what I'm hearing from this witness. And then I'm also finding stuff out that I did not know before. I'm laying the foundation for the admissibility of exhibits. And I'm even preserving testimony so that I'm not worried about it disappearing. And then I'm trying to discover those surprises and make them go away. This discovery approach to deposition, going from broad to narrow, encompasses the funnel technique, the multiple funnel technique that you viewed in other presentations on deposition. In fact, if you're watching this on the YouTube channel, you've probably seen the lecture on the fundamentals of deposition. And this should sound familiar to you, and it's sort of the workmanlike way that we approach these sorts of issues, and it's a classic thing to do. The problem is that when I look at this discovery approach in civil litigation in federal court, and I consider the impact of the change to Rule 26 of Civil Procedure and Rule 37, this opens the door to an opinion that is not contained within the expert report. In fact, it almost invites it. It entices the expert to come up with the answer to the question that you've posed. It educates the expert on your case and puts them in a position where maybe they now can strike at trial, where you're going to be less prepared to deal with it. You may have spent your best bullets on the battlefield of the deposition. I'm not saying that you should not do that. I'm saying that you should do it intelligently. Now, on the other hand, if I look at a confrontational approach to dealing with the expert, let's say I'm going to depose, but I'm going to depose in a confrontational fashion based upon my understanding of the Federal Rules of Civil Procedure and the Federal Rules of Evidence. The first thing I'm going to do is I'm really going to dig into that expert report. I'm going to get my expert to dig into that expert report, and we're going to find the chinks in it if they exist. We're going to find the gaps, the places where we can work our way in and maybe destroy or disconnect the opinion of the expert from the facts of the particular case. And we're going to perform an in-depth analysis before we ever decide to depose. And we may or may not address the report in the deposition based upon that analysis. We're going to look at all of their past depositions. We're going to look at where they've testified before, what they've testified, what they've said. How does what they've said previously comport with what they're saying now? Are they showing us a bias? Bias always being useful. And then I'm going to look at their writings. You know, is this the kind of expert that speaks out of both sides of their mouth based upon who's writing the check? Or is this the type of expert that has a principled approach to the particular issue in question? And then I'm going to look at the materials that my experts looked at versus the material that their experts looked at. And I'm going to ask myself, is there value to confronting their expert with this information that apparently was not considered? Now, there may be value to it in that I might be able to push them off of their opinion during the deposition, but I've also now educated them, giving them an opportunity to answer and make their opinion more effective if we get to trial. So I need to think about that, and I need to look at the key elements of their opinion and ask myself, is there a place here where I can attack but not open myself up to a subsequent opinion that's now going to be admissible even though it wasn't contained in the expert report? And then I'm going to play with the bias of the expert, because bias is always interesting in an expert witness. Bias is for or against parties, for or against issues. Cause experts are phenomenally interesting in that regard because there's always a fruitful ground of inquiry from a deposition perspective that has nothing to do with the opinion, but has everything to do with the partiality or the impartiality of the expert. Any fallacies in their logical reasoning, whether it's in a factual fallacy of how they put the facts together, or a logical fallacy in the way that they've reasoned the opinion itself, and maybe they just don't have the expertise to testify. And can I get stuff out of them that supports my expert? Now, when I look at this confrontational approach, the thing that comes to my mind is that I now, when deposing an expert, absolutely have to make certain that I am doing it both strategically and tactically, that I'm looking at the federal rules of civil procedure, I'm looking at the federal rules of evidence, I'm considering it in the overall overarching theme of my case. I'm looking at what informal discovery I've already done that may supplant the need or modify the need for the deposition of the expert. And then I want to leave you with this quote from a great fellow named Utah Phillips, because I know a lot of you are concerned about experts. You worry about deposing them. You worry about dealing with them. You think that they're dangerous. I've got one good friend who describes examining an expert like getting in a cage with a shark. It's a little bit dangerous. Another one describes it as though when you're on the facts, you're on the island. When you're in the water, you're with the expert. I want you to look at this quote from Utah Phillips, because I think it's just it's a great way to think about them. Remember, an X is a has-been, and a spurt is nothing more than a drip under pressure. Till next time, I'm Charlie Rose. I hope to see you down the road.